If you possess a green card and you travel internationally, this video could be the most important thing you watch before your next journey. We are witnessing something occurring at American airports right now that is affecting lawful permanent residents across the country. People who have done everything correctly, paid their taxes, built their lives here, and who are suddenly finding themselves directed into a separate room the moment they step off a plane. And what is occurring to some of these green card holders is something that most people simply do not know about until it is too late. So today we are going to walk through exactly what is going on, why it is occurring, what your rights are, and most importantly, what you can do right now to protect yourself. Stay with me because this information is genuinely critical for you or for someone you love. As of March 15th, 2026, immigration attorneys across the United States are reporting a significant and documented increase in the number of lawful permanent residents, that is, green card holders, being subjected to what is called secondary inspection when they return home from international travel. Secondary inspection is when a Customs and Border Protection officer known as CBP pulls you aside after you land and takes you to a separate area for additional questioning. And this is not just a longer line or a quick extra check. Some green card holders are being held for hours. Some have had their phones and laptops seized. Some have been asked to sign a form that could take away their permanent resident status entirely. And the landscape in 2026 is unlike anything we have seen in recent years. So let us start at the beginning and understand how we got here. When you come back to the United States as a green card holder after traveling abroad, you are inspected by U.S. Customs and Border Protection. That has always been the case, and it is the law. But the critical thing to understand is that CBP will make a very important determination at that moment. They will decide whether to treat you as what the law calls a returning resident or as what is called an arriving alien. These two categories carry enormously different consequences. If you are classified as a returning resident, you have strong legal protections, and you should be allowed back into the country without significant issue. But if CBP classifies you as an arriving alien, you become subject to grounds of inadmissibility, meaning they can potentially deny you entry, place you in removal proceedings, or detain you while your case is reviewed. Understanding this distinction is not just legal trivia. It is the foundation of your rights at the border. Now, what causes CBP to flip that switch and treat you as an arriving alien rather than a returning resident? There are several specific triggers, and you need to know each one. The most common one is an extended absence from the United States. If you have been outside the country for more than 180 days continuously, that is 6 months, CBP can begin questioning whether you intended to abandon your permanent residency. If your absence stretches beyond 1 full year without what is called a reentry permit, the government can presume that you have abandoned your status. But beyond time abroad, CBP can also classify you as an arriving alien if you have certain criminal history, including some offenses that might surprise you. If you have ever been convicted of an offense, even something minor, even something old, even something resolved years ago, that could trigger secondary inspection and in some cases attempts to remove you. According to the National Immigration Law Center, under current enforcement policy, even a single old substance possession offense can be used against a green card holder who is returning from travel, even in cases where the same charge would not be grounds for removal if the person had never left the country. That asymmetry is something many people do not realize. Additionally, in 2026, we are seeing something new being added to the equation: the scrutiny of your digital life. DHS has significantly expanded social media monitoring as part of its immigration enforcement strategy. CBP officers now have the authority to review your phone, your laptop, your tablets, and your online presence, including social media accounts during secondary inspection. Reports from immigration attorneys and from publications like Borderless magazine have documented instances where CBP has reviewed a traveler's social media during inspection and used what they found as part of their admissibility review. A CBP proposed rule, which was under public comment review through early February 2026, would go even further, potentially requiring social media history disclosures as part of the entry process. While that rulemaking is still ongoing, the practical reality is that device searches and social media screening are already occurring at the border right now. If you are a green card holder, this means your digital footprint is part of your risk profile when you travel. So, let us talk about what actually occurs when you are sent to secondary inspection, because understanding the process will help you stay calm and protect yourself if it ever occurs to you. When CBP takes you to a secondary inspection area, you will likely be asked detailed questions about your travel, where you went, how long you were there, why you stayed, what you were doing, and what your ties to the United States are. They will run background checks and record searches. They may take your fingerprints and photograph. They will inspect your documents, including your green card, your passport, and any visas. They may take your phone or laptop. And this is important. You can and should request a written receipt for any devices they take from you. Secondary inspection can last anywhere from a few minutes to several hours, or even longer if significant issues arise. The fact that you are sent to secondary inspection does not automatically mean you are going to be denied entry. Many people go through secondary inspection and are admitted without incident. But knowing how to conduct yourself in that room can make all the difference. Here is something every green card holder traveling internationally needs to hear, and I want you to pay very close attention to this. If an officer hands you a form called Form I-407, do not sign it. I am going to say that again. Do not sign Form I-407 under any circumstances unless you have spoken with an immigration attorney first. Form I-407 is called the Record of Abandonment of Lawful Permanent Resident Status. And what it does is formalize that you are voluntarily giving up your green card. Once you sign it, you lose your permanent residency. And yet reports from immigration attorneys and organizations, including the National Immigration Law Center, describe officers telling detained green card holders that signing the form will help them avoid detention or make things easier. In reality, signing that form is extremely difficult to undo and may permanently end your life in the United States. The law is clear on this point. You are not required to sign Form I-407. There are no automatic penalties for refusing to sign it. And critically, if you refuse to sign and CBP believes you are inadmissible, the law requires them to issue you what is called a notice to appear, which means your case goes before an immigration judge. That is your right. Only an immigration judge, not a CBP officer at the airport, can make a final determination about whether your green card status is revoked. Now, let us talk about something else that is occurring in 2026 that you should be aware of. According to reporting from multiple credible legal and news sources, there are documented cases where green card holders have been questioned about their political beliefs, their religious practices, their associations, and even their participation in demonstrations or civic activities. This is a deeply concerning development. As a lawful permanent resident, you have First Amendment rights. CBP officers may ask you such questions, but you are not required to answer questions about your political opinions, your religious beliefs, or your First Amendment protected activities. The law firm resources and advocacy organizations that work in this space, including those that have published guidance in coordination with Yale University and other institutions, are consistent on this point. You may politely decline to answer questions that cross into protected territory. You should remain calm and respectful, but you are not obligated to discuss your political views with a border officer. So, what can you do right now to prepare yourself before you ever get to an airport? The steps you take before you travel are just as important as what you do during an inspection. Let us go through them carefully. First, if you are planning to be outside the United States for more than 6 months, apply for a re-entry permit before you leave. This is USCIS Form I-131, and it demonstrates your intent to return and maintain your permanent residency. You must apply before you depart the country, so plan ahead. This is not a guarantee of easy re-entry, but it is an important document in your favor. Second, gather and organize documentation of your ties to the United States. This means things like copies of your most recent tax returns filed as a U.S. resident, documentation of property ownership or a lease in your name, bank account statements from U.S. institutions, evidence of U.S. employment, and records of family members who live here. These are the kinds of documents that demonstrate to CBP that you have always intended to maintain your life in this country, even when you were temporarily abroad. Third, if you are traveling internationally and you have any criminal history whatsoever, even an old arrest without a conviction, even something you thought was resolved, speak with an immigration attorney before you leave. The current enforcement climate means that issues which may have seemed dormant can become flashpoints at the border upon your return. Fourth, review your social media presence before you travel. This is not about hiding who you are. It is about being informed. Understand what is publicly visible on your accounts and be aware that CBP has the authority to and does review social media during inspections. Fifth, before you depart, write down the contact information for an immigration attorney and for your country's consulate on a piece of paper, not just in your phone, because your phone may be taken from you. Share your travel itinerary with a trusted family member or friend. If you are detained, they can help reach an attorney on your behalf. Now, let us walk through what a real scenario might look like, because sometimes the most powerful way to understand this is through example. Imagine a green card holder who has lived in the United States for 12 years. She traveled to care for a sick parent abroad and was gone for 7 months. She comes back to the airport in Los Angeles, and instead of being waved through, she is taken to secondary inspection. The officer begins asking her why she was gone so long, what property she has in her home country, and whether she filed foreign taxes. She is exhausted from the flight, and she is nervous. An officer eventually slides a piece of paper across the table and tells her that signing it will allow her to leave sooner. She does not know that this is Form I-407. This scenario and variations of it is what immigration attorneys across the country are describing. The lesson is not to panic her or to panic you. The lesson is that if she had known beforehand what Form I-407 was and what it meant, she would have been able to say clearly and calmly, "I do not wish to abandon my lawful permanent resident status. I decline to sign this form. I would like to speak with an attorney." That is your script. Memorize it. You have that right under the law. There is also an important development related to biometrics that green card holders should know about. A CBP final rule that took effect in December 2025 expanded the requirement for biometric data collection, meaning fingerprints and facial photographs from virtually all non-citizens entering and departing the United States. This is now broader than it was previously. USCIS is also separately proposing an expansion of biometrics collection for immigration benefit applications, including green card renewals and naturalization. While some of these proposals are still in rulemaking stages, the direction of policy is clear. Screening and vetting have intensified across the board, and the infrastructure being built in 2026 is designed to be more comprehensive and more technologically sophisticated than anything that existed in prior years. Artificial intelligence tools are now being used as part of the vetting process, according to USCIS communications about their new vetting center. What about if you were detained overnight or transferred to immigration detention? It is a frightening possibility, but you still have fundamental protections. You have the right to contact your country's consulate. Under the Vienna Convention on Consular Relations, your consulate can help you reach a lawyer, communicate with the U.S. government on your behalf, and monitor your conditions in custody. You have the right to ask for an interpreter if English is not your first language. You have the right not to sign any documents without understanding them fully, and you have the right to a hearing before an immigration judge before any final decision about your green card status can be made. If you are in that situation, the most important thing is to ask for that hearing clearly and to not waive that right under any pressure. Keep repeating, "I want to appear before an immigration judge." That is your right, and it is protected under immigration law, specifically the Immigration and Nationality Act. One final area I want to address is the question of green card holders who are nationals of countries now covered under the expanded travel restrictions signed into effect on January 1st, 2026. That presidential proclamation covers nationals of a significant number of countries, 19 under full entry restrictions and additional countries under partial restrictions. Now here is the important clarification directly from DHS guidance. Lawful permanent residents, meaning green card holders, are generally exempt from these travel restriction policies. The restrictions are primarily aimed at nationals of those countries who are outside the U.S. and do not already hold valid visas or resident status. However, immigration attorneys are advising green card holders from restricted countries to be especially prepared with documentation and to consult a lawyer before any international travel, given the heightened scrutiny environment that exists alongside these proclamations. Do not assume your green card automatically insulates you from all border scrutiny if your nationality or travel history raises flags under current enforcement priorities. Let us bring this all together with a clear summary of what you should do right now, today, before your next international journey. Pull out your green card and check its expiration date. If it expires within 6 months, begin the renewal process immediately through USCIS. Gather your evidence of U.S. ties, tax returns, lease or mortgage documents, bank statements, employment records, and keep a digital copy somewhere you can access it. If you plan to be outside the United States for more than 6 months, file Form I-131 for a re-entry permit before you leave. Review your social media accounts and understand what is publicly visible. Write down the name and number of an immigration attorney on paper, not just in your phone. Know the phrase, "I do not wish to abandon my lawful permanent resident status. I decline to sign this form. I would like to speak with an attorney," and always consult directly with a qualified immigration attorney if you have any criminal history, prior immigration issues, or if you are a national of a country under heightened scrutiny. Before I close, I want to acknowledge that this information can feel heavy. I understand that many of you have spent years building a life in this country. You have followed every rule, done everything asked of you, and the idea that you could face serious trouble simply because you came home from a journey is genuinely unsettling. But my purpose in sharing all of this is not to frighten you. It is to equip you. Knowledge is protection. The green card holders who have the worst outcomes at ports of entry are often the ones who did not know what was occurring and signed documents they did not understand under pressure. The green card holders who come through secondary inspection without losing their status are very often the ones who knew their rights, stayed calm, refused to sign Form I-407, and asked to see a judge. That is the difference knowledge makes. So share this video with anyone you know who holds a green card and travels internationally because they need this information. As always, please keep in mind that immigration policy can and does change, and the situation in 2026 is evolving quickly. The information in this video is accurate as of March 15th, 2026 based on CBP guidance, USCIS policy, DHS directives, and reporting from credible outlets. But I strongly encourage you to verify anything specific to your situation directly with official sources. That means us.gov, cbp.gov, and dhs.gov, and to consult a qualified immigration attorney for personalized advice about your individual circumstances. Nothing in this video constitutes legal advice. Every immigration situation is different, and only a licensed attorney who knows the full facts of your case can give you guidance tailored to you. This is what America Door is here for, to make sure you have clear, honest, up-to-date information so that you can navigate this landscape with confidence. If this video helped you or someone you care about, please give it a like and share it right now. That one action could literally make a difference in someone's life. And if you are not already subscribed to this channel, subscribe today and hit the notification bell because we are covering developments in U.S. immigration policy continuously and you do not want to miss a single update. Check the description below this video for links to official USCIS and CBP resources as well as guidance on finding qualified immigration legal help. We are in this together and we are going to keep you informed every step of the way. Thank you so much for watching.